right, low AP government. Today I think I'm going to lecture on the day one of our court unit, and so it'll cover notes 1 through 3, and then in the textbook reading, that's 343 to 359. Okay, it's our introductory day, so I thought I'd get into a couple big picture items. First, the Constitution in Article 3 essentially creates one court, the Supreme Court. And then it gives Congress the ability to create all those inferior courts. And so what our legal system has been generally, the court system, the federal system, are 3 levels. We have the appellate courts, we have the district courts, of which there are 94 district courts. And this is the entry level for the federal court system. And then the next level are the circuit courts or appellate courts. And there are 13 circuits of appellate courts. And then finally, at the top, the Supreme Court, which again, there's only one of those, of course. And so what happened is Article 3 creates this. And then Congress created these. And something that we bumped into pretty much in day one with Marbury v. Madison, which is the Judiciary Act of 1789, created these lower levels of courts. Now, what you also have to understand is that in America we have a dual system of courts, which means the states are going to have their own courts, going from the state Supreme Court all the way down into city courts, traffic courts, county courts, etc., right, that deal with state issues. And our focus is primarily these Article 3 levels right here. A couple things too is that you have to understand jurisdiction. Jurisdiction is the ability of a court to hear a case. And so each of these has a different type. The district courts have original jurisdiction, which means all federal cases in which the federal courts have jurisdiction will start here, in its original jurisdiction. The appellate court, or circuit courts, as its name indicates, has appellate jurisdiction, which means they will hear cases on appeal from the district courts. If somebody loses here, they will appeal to here. The other thing is the Supreme Court has both types, original and appellate jurisdiction. Now, generally a case will work its way up from the district courts. If somebody loses, they appeal, and then to the Supreme Court. Now, from the states will have their legal systems in which it culminates at a state Supreme Court. And that state Supreme Court, if somebody loses there, they'll appeal to the United States Supreme Court on appellate jurisdiction. The vast majority of the Supreme Court's jurisdiction or cases come through appellate jurisdiction. Very few come to it through original jurisdiction. The other thing, let's see here. So I guess we need to look at the types of law within our system. This is the general outline of the courts. All right, we'll get more into detail on those in a bit. We have 4 types of law, 2 of which kind of outline a legal system. We have statutory law, which you know is just legislation. So they write laws, say making speeding illegal. That's a statutory system. They see a problem, they write a law to fix it, to address that problem. That's generally, the United States follows a statutory system. We also, though, have influences from our British ancestry in the common law system. The common law we won't spend a lot of time on, but it's important to kind of understand the idea behind a common law. Common law is based upon precedent, which means previous decisions. And so, to simplify, common law is based upon experience, and it's judicial lawmaking. The courts are making the law. And so what will happen, let's go back to the beginning of time, the first chicken thief, right? And you have a court case in which the judge says, this is the sentence for chicken thievery. And that sets a precedent. So the second chicken thief comes along, and they already have a court case that tells the society how to deal with that issue. And so if it was, you have to replace the chicken and you're banished for a year, there's the precedent. Common law evolved over hundreds and maybe thousands of years in the British legal system, responding to society's problems. one of the big concepts within common law is the idea of stare decisis, which is Latin for let the decision stand. And what that does is common law, through all these cases, will build a big body of law in which to rule a society. So similar cases arise again and again and again and again throughout a society, and so judges and civil authorities can look to the precedents and use stare decisis to kind of guide them in their actions. Now, I think in the American political system, this idea of common law comes out of our courts, and it's kind of unique. But what advocates of the common law system will say are that it evolves over time as the society evolves. It adapts and changes to society's needs, and it's very flexible. Whereas a statutory system will say, here's the problem, here's the law, this is how we're dealing with it, which will again be based on experience and things like that. But the law kind of clearly defines what the problem is and the solution is. Common law and stare decisis evolve over time, and they build this big set of precedent in which to guide a society. I think for all intents and purposes, we use court decisions as precedents to guide our legal system. Okay. The other thing about our courts is we have criminal and civil law. Criminal law deals with violations against society. You know, rape, murder, armed robbery, and generally what we assume in criminal law is that society itself has been wronged, and therefore the government prosecutes against that, and then those people have to defend themselves. The other kind of law we have is civil law. And what civil law is these are disputes between two parties rather than violations against societies. Some good examples are divorce is civil law. Slander, medical malpractice is civil law. Violating a contract is civil law. And therefore, because we don't assume that society's been wronged, you and I as individuals have the obligation, or we have to, bring these cases in front of the courts to try to get our money back, to get paid correctly, to right a wrong of some kind. So, statutory law, legal or written law, common law, which is a series of laws based upon precedent and experience and unwritten, and then we have criminal and civil law, which common law and statutory law deal with both civil and criminal issues. All right? Okay. Another thing about the courts is the court's power is passive, which means the court has to wait for cases to come to them before they make rulings. The Supreme Court or the district courts or the circuit courts cannot just kind of reach out and say, if that happened, we would declare that unconstitutional. Or if somebody brought that law before us, this is how we would define the law. We have to wait for cases to come to them, which we'll get to how they come in later lectures and later classes. People have to wait for that. So the power is passive. So it may take time. If you lose legislatively, if you lose at the executive branch level, and you want to get into the court system, it can take some time because it's got to get to the courts, make its way through the legal system before you're going to get a decision. Also, to get a decision or to get in front of a court, you have to have something called standing. Just because you don't like something, you can't sue to have it ruled unconstitutional. You have to have been impacted by the action, the law, the interpretation of the Constitution in some way, shape, or form to have standing. For example, a number of years ago, a father in California he was an atheist, and he was concerned when his daughter was saying the Pledge of Allegiance every day and saying under God that she was praying to a God, and he didn't like that. He had standing because his child was in the school system, and being the parent in charge of her, he could challenge that. If you were somebody that didn't have kids and you thought that saying the Pledge of Allegiance with under God in front of school each day violated the separation of church and state, which we'll get to a whole nother day, you couldn't sue. You don't have standing. So you must be impacted by the case. All right. Now, the other thing is this idea in the notes in Roman numeral 4 of judicial lawmaking. I think what you guys have to understand is the Supreme Court has a number of powers. One, based on Marbury v. Madison, which said which essentially creates the power of judicial review for the courts to overturn federal action, and Martin versus Hunter's lessee, that's a hint for extra credit on the multiple choice, or on the quiz, said they could strike down state laws as unconstitutional, or at least interpret them, uphold them, strike them down, whatever. So they get to have the power of judicial review, which means they can review laws, all right, and decide if they are constitutional or not. They actually define the Constitution itself through their decisions. When people come to them and they say, what does equal protection mean? What is full faith and credit? What is privileges and immunities? What else have we looked at? What is commerce? Right? That kind of thing. All those inherent powers of the presidency that we looked at. They'll quite often define these. So the Supreme Court is defining the Constitution. Now, there's some interpretations of that as should they be doing that, which again we'll save kind of for a later day. But the Supreme Court will often, what we've learned is that Congress writes broadly worded laws. And when they write broadly worded laws, and those laws are implemented, people have conflicting views of what those laws mean if they're broadly worded. And therefore, quite often, it's the court's role to settle those disputes and say what the law is. So not only are they defining the Constitution through their cases, they're defining sometimes what laws mean. Now, the other big power they have, kind of going back to the common law system, is they have the power to overturn precedent or previous decisions. I think the easiest and most apparent example of that is Brown v. Board. We have Plessy v. Ferguson that looked at the 14th Amendment's Equal Protection Clause, and it said equal protection means separate but equal. That was the definition of the Taney Court of the Equal Protection Clause at that time. You fast forward roughly 60, 70 years to 1954 with the Warren Court, and they get the Brown v. Board case, and their definition of equal protection under the law is radically different than the Taney Court, and they say that separate but equal is inherently unequal. And therefore, by overturning that past precedent, they've set a new precedent for the interpretation of what the Constitution means. And then therefore, any action that city government, state government, or national government takes has to understand that anything regarding equal protection under the law has got to be viewed in the Supreme Court's interpretation of it. Now, according to stare decisis, the Supreme Court is not overturning themselves all the time. Stare decisis and precedent gives stability to our legal system, so we kind of know the definition of what the Constitution is. But it doesn't mean they won't overturn it at times when society changes and the Supreme Court changes their decision of what it means. Okay, let's see, let's move on to that page 2 of the notes, and let's move into jurisdiction. I think one of the things you have to understand is the federal courts have jurisdiction over a number of issues, and your notes talk about it. When the Constitution is involved, when a federal law is involved, when ambassadors are involved. There's very specific guidelines to when the federal courts can hear a case. And just kind of as an aside, note that the circuit courts or the appellate courts will never be the court that hears a case for the first time. They have appellate jurisdiction, and they can only hear it on appeal from the lower courts. And then the Supreme Court has both original and appellate, but they will hear things on appellate from the lower courts. All right? So you're going to want to definitely look at Roman numeral 6 on page 2 and kind of get those into your brain of when the Supreme Court or when the federal courts will have jurisdiction. A number of years ago, Nevada had a fight about our budget and funding education. A group of people lost in the state courts whether or not we were going to fund education, and so they believed that they had standing to get into the federal courts. And when they got into the federal courts, the federal court said that the case itself was purely a state issue, and therefore the federal courts had no jurisdiction whatsoever and kicked it back to the Nevada State Supreme Court and said that decision stands. Purely state issues are going to stay in the state courts. Now, if a state law violates some element of the Constitution, whether it be your natural rights, some element of it, then the federal courts will get involved. All right? Let's see here. Article 3 courts. All right, a couple things. Article 3, remember, the only court created in the Constitution clearly and explicitly is the Supreme Court. All right? The district courts and the circuit courts were created by Congress in the Judiciary Act of 1789, as the Constitution says, Congress can create those lower courts. All right? And what you also have to understand is all of these federal courts, the judges within them have life terms, or the Constitution says for good behavior. All right? And generally that's interpreted as life. You can be impeached, you can die, you can resign, all right? But you have those terms for life. Now, we'll read Federalist 78 in class, and Hamilton kind of justifies why you would give people life terms, because as you can see in 1789 or during the ratification debates, or even today, some people have a problem with, you have unelected, appointed people striking down actions in the Constitution, actions by democratically elected legislatures, democratically elected executives, initiative, referendum, and recall, or initiative and referendum at the state level, democratic institutions, they're striking them down. Now, the idea is life terms insulate federal judges from immediate politics. The idea is we don't want the judges being swayed by public opinion, by polls, as a weather vane would. The idea is the Constitution has this set of principles that are supposed to guide judges when they make decisions. The analogy is there's supposed to be an impartial referee, and they look to the Constitution, they look at the actions of the state legislatures, the federal legislature, executives, etc., citizens, and they try to define the actions by reading the Constitution. Now, what we're going to see is that's not so easy. The Constitution has some big principles that should guide people. However, there's some ambiguity within them, and then we get a group of people that say it should be interpreted very strictly, like the framers wanted, which is a difficult thing to attain. What was the true idea? What were the absolute beliefs of the framers? We know big picture stuff, but do we know the specifics? And some people will say yes. And then others will say that the document's ambiguities allow it to evolve over time to changing society. But the idea behind life terms is judges will have the Constitution, and therefore the fundamental principles written in that Constitution is guiding them, rather than Congress, rather than state legislatures, rather than the executive branch. It's the Constitution, or the highest law in the land, that guides their decisions. And that's the ideal, and we'll see the nuance to that later. Okay, so that's the life terms. Now again, going back to kind of the district courts, about 90% of all federal law is handled at the district court level. These cases here are tried by a judge and jury. So one thing you want to understand is a grand jury at the federal level, or at any level, a grand jury is a jury in which you're called to jury duty to hear the arguments to both sides, to just simply decide if there's enough evidence to go to trial. Grand juries don't decide guilt or innocence. Grand juries decide whether or not there's enough evidence to go to trial. And they will hold what's called a petite trial, which is what you know. You got a judge, you have some lawyers, you have the jurors in the juror box deciding guilt or innocence in criminal or civil laws we kind of talked about earlier. All right? Now, a couple things is, civil and trivial. These decisions, if you lose here, you will appeal, if you want, to the circuit court. Now, these judges at the circuit court meet in 3-judge panels. And if you look on page 356 in the textbook, there's a nice map of the 13 circuit courts. There's 11 around the country and then 2 within D.C. itself that give us the 13. And like we, out here in Nevada, we live within the 9th Circuit Court. So any district court, all states have at least one district court. Some have more, like California. I think California and Washington have more than one district court. So if you lose here, you'll appeal to the 9th Circuit Court in which is centered in San Francisco. These judges meet in 3-judge panels. And I think these are randomly generated. All of these judges, by the way, at every level, are appointed by presidents and confirmed by the Senate, like we've talked about. All of these for life terms. And these people meet in 3-judge panels. And so you win or lose, 2-1, 3-0, that kind of thing. All right? And usually what they're ruling on is whether the lower court's actions were constitutional. Did you lose any of your constitutional rights in the legal proceedings down here? Sometimes they can meet en banc, which, as a whole, I'm not quite sure the exact number of judges, all the number of judges on each circuit court, but sometimes they can meet as a whole to rule on something. I know, going back to that Pledge of Allegiance case, the 3-judge panel had said the under God part of the Pledge of Allegiance violated separation of church and state within the Establishment Clause in the Constitution. And there was a pretty big uproar, and what happened is the judges came back together and met en banc and kind of overturned that decision. So that decision was dead. They can do that. And they only have appellate jurisdiction, so people appealing from here. Okay, let's see. En banc, petite trials, jurisdiction. Yeah, and then if you lose at the circuit court level, you can appeal to the Supreme Court level. All right? And just kind of, again, an overview. Common law is a set of laws, a legal system built upon precedent, not written law. Judges kind of defining crimes, defining punishment, where a statutory system is a written legal system, which we know, we've studied all year, the legislative branches write those laws, and then our courts interpret what those laws mean at times. What you want to think is try to think about how the court plays a role in everything we've looked at all year. They can rule in the actions of individual citizens, they can rule in the constitutionality of the actions of the federal government, the state governments, city governments. But the idea is that the judicial branch's main goal is to interpret the Constitution, interpret broadly worded laws, and then to use stare decisis and precedent to kind of give consistency to our legal system. We'll kind of dive, that's just a big intro, but we'll dive into more detail in later days. All right, Cougars, see you later.